Well, hello again, and welcome to part 2 of To Pupillage and Beyond. Last week, we told you about the journey from application to obtaining tenancy. If you missed it last week, you can find it on YouTube, so I do recommend you to go there and watch it. This week, we're going to do much the same kind of thing, but we're looking at what happens after tenancy. And we're going to try and give you some insight into some of the ways you can develop and expand your practice. Please do use the Q&A button to answer questions as we go along. We will try and answer them either on the Q&A or live at the end of the talk. We've allowed quite some time for questions because this process is really about you and helping you decide if the bar is right for you and what direction you might go afterwards. One of the questions we keep being asked is how someone chooses their area of law. Those of you who watched last week will recall that Tabo told you that as a direct result of lockdown, he has developed a practice in maritime regulation, something that was not even on his radar 4 months ago. It doesn't happen quite like that for everyone. And in a multidisciplinary set like 3PB, that is not necessarily a problem. I'm going to turn now to one of our very recent tenants, Jane, to talk a little bit more about that process. Jane, take it away.
Thanks, Cheryl, for the introduction. Morning, everyone. My name is Jane Ye. I'm one of the newest tenants at 3PB. I got my tenancy just last October upon successful completion of my pupillage at Chambers. My practice area are commercial, chancery, and construction laws. I would like, as Cheryl said, I would like to share with you some of my experience about choosing my practice area and the life or tips first year into tenancy. When it comes to choose your practice area from early point, I'm sure most of you would do that step anyway, but to me, the very first step is to have a basic idea about the area of law in which you are interested through researching, doing mini pupillages, and have a good think about your natural talents and where that could be best used. Just before I start my pupillage, Chamber asked me to identify the works I wish to do so they could assign me to a suitable supervisor. To find answers, I divided the Chamber's practice area into 3 categories. The first categories to me are those I'm definitely interested in. I only have, at that point, only one area into it, that's commercial law. And the second categories include those areas I didn't mind of doing, for example, professional negligence, employment, and construction, etc. The third category I would call is the no-no category, which I couldn't picture myself doing at all. For me, that's crime and family. And then I was able to tell Chambers that I want to do commercial work. Then they signed me to my first supervisor who specialized in commercial practice. The second step or the second tip finding the area of law is to keep your option open. As I mentioned at the beginning of pupillage, even though I knew I wanted to do commercial works, it was rather a vague concept, commercial, and well, my then co-pupil all came in with very specific areas in mind, what they want to practice. So in order to find my area, I decided to try as many areas as possible through shadowing and doing works for different members of chambers from different practice group, as I believed that the real knowledge and insight from the practice area actually came from practice. So by keeping my option open, i.e. not saying no to other area of law, like other works, say for crime and family, I actually managed to narrow down the practice area that I'm interested in. Give you an example. Through doing personal injury cases, especially road traffic accident cases, I found out, I soon came to the realization that the fact I did not drive make it extremely difficult for me to come to a good case theory and ask efficient questions during cross-examination. And the third tip I would say is to be honest with yourself. I'll give you an example. During the first 6 of my pupillage, I thought I would be interested in education law. So I did some work and shadowed 2 members of the education team. It soon became clear to me I just couldn't understand education law at all. Even though I did essential reading, etc. I asked myself, could it be the case that just give me a little bit more time, I would develop the interest? And I was honest with myself. The answer was no, it's just not my cup of tea. Then the fourth step, I would say, is very important one, is to communicate with your pupil supervisors. This is very important because not only because of their expertise, their experience into the practice areas, but also because of the bystander effect. Cheryl was my second supervisor. We'd sit down at least for 3 times during my pupillage to discuss the area I could develop into. Through reviewing my paperwork, she pointed out that I demonstrate very strong analytical skills and good understanding of professional negligence claims. So it could be an area of law that I can develop further. She also noticed that I really enjoy legal analysis, legal debates in the way I draft my advice, which make me suitable for chancery works. Then the fifth one, a tip, which is definitely not the last, but given the time limit, I would say, is to talk to your clerks. As mentioned earlier, one of my practice area is construction law, but I actually did nothing construction law related whatsoever during my entire pupillage. It's only when, after I got my tenancy, I sit down with senior clerks in London and asking for their advice, asking how I could develop my career. The senior clerk of our construction team, Steve, told me that according to the feedback he received from solicitors and other members of chambers, he believed I had the right skill for construction law, construction works. So here I am, gradually develop my construction practice alongside with commercial and chancery matter as how I narrow things down. And now I want to talk a little bit about the first year into tenancy. Life of tenant is totally different from the life of being a pupil. More flexible, you will enjoy a lot of flexibility, but at the same time, a lot more responsibilities, because you wouldn't have your supervisor there to check your work, to hold your hand, go through everything. You are your own business, you are yourself. But first year tenancy is just the beginning of your career. There are a few things I would say quite important lesson I learned through my 9 months into my first year tenancy. The first I would say is to prepare to go to court much earlier than you needed to. Ideally 1 hour before the hearing. I had one case, the court changed the venue of the hearing literally on the day of the hearing. I didn't find out until I got to court. Because I got called an hour early, I managed to travel from one to another and still attended the hearing. The second one I say is to have a habit to type up your attendance notes and send to solicitor as soon as possible, ideally on the same day, because your memory will be you will have fresh memory, you know what you want to emphasize. The longer you waited, the vague your memory could be. The third tip I would say is do not be afraid to ask a member of chambers questions. Even now, I still ask my formal pupil supervisors all sorts of questions. At one time, I called Cheryl 5 minutes before one of my hearings about insolvency matter, because my opponent just raised like a legal point which I know nothing about. The fourth tip I would say is always talk to your clerks, because they are there to help you develop your practice. As I mentioned, I soon realized professional personal injury case is not my cup of tea. I talk to my clerk, and that has been removed from my practice area, which enable me to focus more in develop construction, commercial, and chancery work. Well, I think this is the right time to hand over our discussion to Stuart Pringle, one of our senior clerks, to hear his perspective from the clerk, the relationship, how to do with clerks. Stuart.
Thank you very much. I'm Stuart, and I've been, for my sins, I'm a director at 3PB. I've been in chambers for over 30 years, and as you can see, I've earned the grey hairs, which seem to be compliant with regard to lockdown. Today I'm to provide you with an insight as to the relationships and the work that's expected from both members, pupils, and clerks. Firstly, I should enlighten you as to what a clerk actually is. A clerk is somebody who administers and manages chambers. The title is slightly historic and doesn't really reflect today's modern world. And there are many variations of those titles today, from clerk, manager, practice assistant, wizard, magicians have all been used, and those are the ones that are printable. However, the role bluntly consists of managing diary, individuals' practices, ensuring cases are billed, fees are incurred and received, and to market and develop everybody's practices, both financially for chambers as a group, but also for its members individually. Clerks are employed to manage chambers as a collective, but also each barrister, and that's from the pupil to the barrister, individually. And there are many occasions when effectively these roles are in direct conflict. The needs of the many does not always outweigh the needs of the few or the one. And as you can see, it can be a quite difficult practice. Chambers will provide you with the opportunity to shine, to make yourself indispensable, enable you as pupils to become the next addition to chambers, and if you're members, to hopefully evolve, become very successful and become QCs or judges. We want to invest time, money and effort into you, and individually we don't want to waste that time. We want it to be very successful. To the point of this talk, it's with regard to the relationship between barrister and clerk. It is symbiotic. Together we hopefully can achieve great things and be very successful. Good clerks are called counsellors, negotiators and fixers. A fixer is most probably the most important term, but do not assume that refers to just a brief fee or a diary conflict. Management of egos, disagreements between members, solicitors, colleagues and friends all raise their heads. The nature of the base of returning at late returns of papers, people being asked to work very late, unsociable hours, all factors that need to be taken into consideration. Yes, a clerk could be slightly Machiavellian, but you need to have trust and faith in your clerk. They're there to develop and nurture your career, but consequently you have to have trust in them, and they also have to have trust in you. It is a two-way street. You have to, and this is not something that happens overnight. This takes time, and this needs effort from both sides. The relationship between a clerk and a barrister is a weird one. The role of master and servant is blurred. We have many occasions where I get praised fantastically for all the good work that my barristers do, and I've had no involvement in it whatsoever. I also am the voice, or shall I say, I am the blame for all the reasons why things don't go right. So people being late, late delivery of papers. So it's very, very strange relationship. But it works, but it works together as a collective. As a trainee, as a barrister, as a pupil, the clerk will introduce you to many of the contacts that they have built up over many years. It's a recommendation from them to you, and this is an opportunity for you to shine. But as you can imagine, a bad recommendation by a clerk that fails, consequently could lose that client, and that you could lose that relationship between not just for the individual but for the whole of Chambers. So these things are not taken lightly, and they are given a great deal of thought and consideration about it. During your pupillage, you're encouraged to have meetings and chats and discussions with your clerk. It's very important to build up rapport. You need to understand them, they need to understand you, they need to know your strengths and weaknesses. As you can imagine, some clerks have weaknesses as well, so you need to be able to address and sort of rapport with them. The 12 months flies. There's lots of work to do in a very short period of time, and you need to control it, but it needs coordination between both you and your member of staff. You have lots to do. Practices are constantly evolving and changing. Work resources and revenue resources that you thought would appear will disappear, may not materialize, but together you will be able to adjust and adjust the problems and make your practice evolve. Now, what you should know about Chambers is not run to make profit. Chambers is managed to take a percentage of tenants on what they receive, not build, and that contributes to the expenses that are incurred to run the business. The clerks in 3PB are on salaries. They get no financial gain from the brief or fees that you get paid. However, they do have a vested interest in making sure that you get paid appropriately for the work that you do. As you could imagine, a happy barrister is a nice barrister to work with. And so we are all there to make sure that everybody is pulling in the right direction. You must know that members of Chambers are self-employed. So if they don't work, they don't get paid. Chambers does not provide sick pay. So it is a difficult choice. It is a difficult life. This places a great burden on you. However, you are choosing a fantastic, constantly changing, evolving profession, but you are not choosing the easy profession. First year pupils do not have to pay any contribution towards Chambers. Successful pupils learn their trade, they do Chambers work, they hopefully create their own work and assist Chambers to evolve and progress. But in financial terms, they do not become a net contributor until the third year. The money, the time and spent training is only realised in that year. So as you can see, we really want for pupils to be successful, to work and progress and become Chambers tenants. The clerks, or whatever title they form, are your allies. They're there to help you and they're there to make sure that your career progresses. Well, they are at least at 3PB. So I hope that gives you a little guide or a little insight into the clerking of Chambers. And I'm now going to pass you on to David, who's going to give you some input with regard to direct access. Thank you very much for your time.
Thanks, Stuart. Good morning, everyone. My name is Matthew. I'm a barrister in 3PB's Bristol office, and I specialise in public and regulatory law. The first question I suppose people have about direct access is what direct access is and how you become direct access accredited. I would suspect that the majority of people watching this know that the legal profession in England and Wales is split. We have solicitors and barristers. Traditionally, barristers' work comes from solicitors. Direct access, on the other hand, allows barristers to accept work directly from members of the public in order to effectively allow members of the public to skip a step and not go through a solicitor. In terms of how you actually become accredited to do direct access work, well, there's two ways. The traditional way is to undertake a direct access course and then apply for registration through the Bar Council. Alternatively, if you've worked in-house or you've been a solicitor previously, you can apply to the Bar Standards Board for a waiver to the requirement to undertake a course and effectively jump ahead of that process. Now, we understand a lot of people watching this are at the stage where they are about to apply for pupillage, or perhaps are undertaking pupillage. So the question then posed is, well, why should students be interested in undertaking direct access work? Now, I would opine that there are three reasons. Firstly, you add another string to your bow in terms of a work stream. You're not just constrained to having to accept work from solicitors. You can then market yourself directly to members of the public and get an additional income stream. Secondly, it may make you more attractive to chambers that you're applying to if you show a willingness to do this type of work. In some chambers, not necessarily at 3PB, the more senior members of chambers like the traditional split between solicitors and barristers and also willing to undertake direct access. If you can show a willingness to do so, that could potentially make you stand in a positive light. And thirdly, it may demonstrate that you have some understanding of the commercial realities of the bar if you can show that you are willing to try to overcome some of the challenges facing members of the bar through doing direct access work. There are, of course, benefits and negatives of doing direct access work. So what are they? Well, from my perspective, there are 5 real benefits and 4 real negatives. So starting with the benefits, as I've suggested earlier, you can add another revenue stream, i.e. you can get income from 2 sources, members of the public and solicitors. Secondly, one of the big problems with being self-employed and being a barrister is the time from incurring fees to actually getting paid. Effectively, the date that your fee note goes out to a solicitor that's instructing you is not the day that you can get paid, and often it can take a fairly lengthy time in order to actually have the money hit your account. Or direct access is slightly different in you're paid in advance of the work you're undertaking. Thirdly, something that barristers traditionally struggle with, or at least that's how solicitors can perceive it, is with client care skills. Now, when you're undertaking direct access work, obviously client care skills are crucial because you're actually having to deal directly with your individual who's got the problem, and therefore undertaking more direct access work can allow you to develop those skills. Linked with that is point 4, in that it gives you more of an insight into how your instructing solicitors work on a daily basis. And fifthly, it can actually allow you to branch out into other areas of practice that you're not necessarily undertaking. If you don't have a background in a particular area, solicitors are not going to instruct you in it. However, you may be able to secure some direct access instructions in that area to allow yourself to build up a new practice area. There are, however, negatives. Dealing directly with your end client is not easy. It's not necessarily as straightforward as having a solicitor client because the demands are entirely different, and therefore you have to get used to that relationship and being more hands-on than potentially you are when you have instructions coming through a solicitor. And linked with that, if you have a particularly demanding direct access client, it can be difficult to balance direct access clients and solicitor clients. Thirdly, you have to really think about marketing your practice because you need to market it in a different way to direct access clients and solicitors. And fourthly, and perhaps most problematically, some solicitors deem you to be in competition with them if you're doing direct access work, so you have to think about how you're going to balance that. That said, there are a variety of ways in which you can try to develop practice. One way is through applying to be on Attorney General's panels, and that is what my colleague Caroline is now going to talk to you about. Over to you, Caroline.
Hi, good morning, everyone. Thank you very much for being with us. I shall confess that this is my first webinar as a presenter, so I'm expecting some kind of technological disaster, so bear with me. Thanks very much, Matthew. So a quick word about me. I have been practicing for about 13 years now, although I don't really care to admit that. I studied law at university, mainly because I couldn't think of anything more original to study when I wanted to be a barrister, although I think that the position has very much changed now, so I would encourage people to study what you really enjoy. And my practice for the last 8 or 9 years has focused on predominantly public law, including education work, and also some employment law too. Although, as many people in 3P buildings, I started with quite a wide common law practice at the beginning. Since 2012, I have been on the Attorney General's panel of civil barristers, or I'm sure there's a formal title for that, which I probably should have looked up. What I'm going to talk to you about briefly this morning is what are the Attorney General panels, what kind of work do you do when you're on panel, and what are the challenges and the rewards of doing this kind of work. So first things first, you probably know the Attorney General is the chief legal advisor to the government. There's both a litigious role, so sometimes the Attorney General you will see appearing in court cases. For example, the Attorney General has a responsibility or a power to challenge unduly lenient criminal sentences. But also they have a very perhaps more well-publicized role giving advice to government on complex matters of law. So the sort of things that have hit the headlines, for example, are Lord Goldsmith's advice to Tony Blair about going to war, the legality of going to war in Iraq. More recently, I'm sure you'll all be familiar with the appearances of Geoffrey Cox, QC, MP at the dispatch box to explain various decisions that have been taken with regard to Brexit. So that's the Attorney General. The next question is, what are the Attorney General's panels? The panels, there are 3 of them. There's one for London, there's one for the regions, and there's one for public international law. And what they are it's a competitive process. You apply to be appointed to the panels. There are 3 levels, so you'll hear people talk about being on C panel, B panel, A panel, and that reflects the different levels of seniority of people at the bar. When you're appointed, it's a 5-year appointment. And the scheme itself, although you're appointed by the Attorney General, is administered by the Government Legal Department, formerly known as the Treasury Solicitor. And the GLD are the solicitors to central government, and they also have a remit in terms of various, sometimes you may get instructions, not necessarily directly through GLD, but from other public bodies like Ofsted and what have you when you're on panel. So that's the panel. The next thing to say about it, and perhaps to dispel any misconceptions, is that when you're appointed to the panel, you remain an independent barrister. So that is one area of your practice. It essentially enables you to do work on behalf of central government, but it doesn't mean that that is all you have to do. And particularly important to stress that you can carry on doing work for claimants. And indeed, I think for many people, for many claimants, it's quite, they see it as an advantage to have a barrister who does work both on the claimant side and on the respondent government side. I say that not because one would, of course, divulge any insight that you have into matters of fact or policy that you gain whilst doing government work, but it's definitely fair to say that government litigation is a different beast. And I think when you bring that to the table, some understanding of that can be a real asset to your client. So yes, it's a door, it opens a door to a really interesting area of work, but it doesn't shut doors to other areas of work either. So here's where the technology bit probably will fail me. I'm going to attempt to share my screen with you. I think hopefully you should now see some slides. What I really wanted to do here was just give you a very brief overview. I set myself a challenge yesterday. How many cases, how many headlines can I find in the last 12 months relating to government cases? I do apologise for starting on a Friday morning with Brexit, but this one was the first one that jumped out at me from September 2019 last year. I'm sure many of you will be familiar with the decision, and if not the decision, with Lady Hale's amazing spider brooch. So really that's what this slide was an excuse for. I'm not going to talk about each slide, but I just want to show you, here's the next one. This is for those interested in environmental work. The government is under, has various duties it's under in relation to agreements that it has signed up to. In other areas, equality duties. It also has duties of consultation. So you often find things like this being litigated in the courts. Immigration, sadly something that's likely to take up a lot of headlines, has done already both before and after Brexit, always a hot potato in terms of government work. This relates to the considerations, this case that the Home Office, the Home Office the things they have to think about when contemplating deporting individuals back to their country of origin. This very recently, this case relates to Shamima Begum, who I'm sure everyone is familiar with, and her attempts that the government have deprived her of her British citizenship on the basis that they consider her to be a citizen of Bangladesh as well. She wishes to challenge that, and the case that the Court of Appeal's decision recently related to the scope, the extent to which she could come back to the United Kingdom to bring her appeal. What did a fair trial require? And the latest word on that is that she should be allowed back. And last but not least, I suppose, to bookend these slides, start with Brexit, finish with COVID, and that probably sums up the year for a lot of us. As you may well know, there are challenges going on at the moment to some of the lockdown restrictions. So you can see from that very quick run through of those slides that the work that you can do when you're on panel is extremely varied. In addition to the matters that I've just shown you, it covers things like inquiries, inquests. I've mentioned working for regulatory bodies like Ofsted. There's tax work, there's pensions work, there's trade union disputes. So whilst a lot of the work is public law orientated, the government need good legal advice from people across the range of civil litigation, as I say, including employment, including tax work. So it's really a fascinating area to get stuck into if you have any interest in government work. So very briefly then, the challenges and the rewards of doing this type of work. I think the top challenge is really understanding the bigger picture, because in any given case that you get when you're on panel, you have to understand that it may have a read over to not only just other cases in that field, but potentially other areas of law, other litigation that the government have on foot. It's not that that changes the legal advice that you give, but you do need to factor in that the advice you give on the facts of your particular case may have a wider consequence. And so particularly if you have different options in terms of the legal advice that you give, or options that you may want to present the client, then you need to bear in mind that part of what they're going to think about is not just how does it apply to this case, but how is this perhaps going to be rolled out into other cases. So that's number one. I think number two is understanding your client's world. That's something, again, that's really key in any area as a barrister. I mean, whichever area any of us specialise in, we all have to jump into our clients' worlds in order to be able to help them with whatever the legal problem is that they need advice on. But when you're advising government, what you have to understand is that sometimes you have multiple clients. I mean, I at the moment very rarely go to conferences where I have just one client. There's normally maybe 3 or 4 different government departments represented. I also have to understand that not all of those clients will necessarily be pulling in the same direction, because they represent different interests in terms of their department's equities. And so it's important that when giving the advice, I understand exactly sort of who my client is and what they need from me, and also how I might need to perhaps facilitate discussions sometimes between different government departments that are involved in the litigation, in order that they both understand what the end goal that we're all trying to get to, which is the same. The third point I'd raise, which really is a follow-on from that, is just that as a barrister doing work for government, you have to be able to accommodate the multiple layers of decision making that go on in government, and in particular in relation to litigation. So what that means, for example, is that when you need to get documents signed off, whether it's skeleton arguments, or pleadings, that is not necessarily as quick a process as it might be if you are dealing just with one lay client. You also have to understand, whichever field of government work you do, that there may sometimes be a limitation on resources. So you as the barrister may have 10, 15 questions but you have to really work out when you ask for those further instructions, what's realistic, what am I actually going to get back, and which are the 5 burning questions that I absolutely need the answers to, and which are the 10 questions that I can hold off until a later conference or until a later day. And also inevitably, because of the multiple layers of decision making, there's often a lot of pressure on your time when it comes to responsiveness and being able to deal with things at speed. And I suppose the final point I'll mention in terms of challenges is not just dealing with things at speed, but also dealing with the unexpected. Partly sometimes because of the subject matter that's involved. Take, for example, immigration cases. You may think you know where you're going with the case, but then suddenly things change on the ground in the country to which you're intending to deport someone, and you have to be able to work out how do you, how do you factor that into your arguments? How does that change the picture? You may often find in government litigation that you're dealing with a case in the domestic jurisdiction, but actually there's been a European Court of Human Rights case that's just been issued that actually has a big impact on the litigation that you're about to do next week in the High Court. So you really have to be able to deal with the unexpected, and also you have to be able to deal with unanticipated shifts sometimes in government policy. Those I present them to you as challenges, but they're in fact part of what makes the work very exciting. So leading then on very briefly to the question of, what are the exciting bits of doing this work? I think the main two really are the variety of work that you can do. You are, as a panel member, actively encouraged to take on different areas of work, which, for whatever reason, if at some point in your career you hit a dead end in one area, or it's no longer of interest to you, it's a really amazing thing to be invited with open arms to think about taking up perhaps a slightly different area. But I think for me, at any rate, the main thing is the sense of purpose. The work that you can do as a panelist really can have an impact and can be immensely valuable to the community around us. And what I would say to you as a parting thought is really, if you have any interest in human rights, if you have any interest in public law in particular, I would invite you to perhaps challenge any preconceptions or misconceptions you might have about doing government work, and think about having a go. And in particular, there is, prior to commencing work on the panel, there is what they call the baby barrister scheme, which is for juniors who may want to have a go and see what government work involves. Particularly government cases tend to involve a lot of disclosure work, and that can be a really good way of finding out what you might be interested in when it comes to doing panel work. So with that, I pass over to David Parrott QC, who's going to talk to you about arbitration and mediation.
Hello, everybody. Yes, I've been asked to talk to you today about arbitration and mediation, sometimes referred to as ADR. You may have heard those letters, ADR, Alternative Dispute Resolution. And what we're talking about here, what we mean by this, is really just different ways, as the name suggests, to resolve disputes. And mediation and arbitration are probably the most well-known, probably to you. But we could add to that, for example, ENE, which there's lots of acronyms in this field. ENE, which is early neutral evaluation, which is another way of resolving disputes, which is gaining some prominence. Alternative in what sense? Well, obviously in the literal sense, it's alternative ways to resolve disputes being alternative to litigation. And what I thought I would try and do with you today is open your eyes to these dispute resolution mechanisms, DRMs, which perhaps weren't on your radar and which you hadn't possibly thought about when you were thinking about developing a practice as a barrister. But what I want to say to you from the start, and make very clear from the start, is that your litigation skills will always be part of what you do as a barrister. And therefore, opening your eyes to different areas of practice is not really alternative in the ADR, but can I suggest to you it's additional. So if you think of ADR as additional dispute resolution, and I want to come on and say something about transferable skill sets, and how, if you learn how to do the job as a barrister, you can do the same job in a different forum, in arbitration. Just perhaps an example, just on that point, the ability to listen very carefully, not just hear, but listen, and to ask questions, direct, relevant questions, one fact per question, is crucially important in mediation. Likewise, in arbitration, the ability to draft pleadings, to work with witness statements, to draft skeleton arguments, to cross-examine witnesses, whether these are factual witnesses or expert witnesses, is applicable, equally applicable, whether you're in court or whether you are in arbitration. And my own personal feeling is that we as barristers need to seriously start thinking about how we adapt, because the market itself is changing. Even in the last 5 to 10 years, and I've practiced in arbitration for 10 to 15 years, but I see an increasing sophistication amongst both corporate and individual clients. They are the ones that are pushing for different ways to resolve the disputes that they find themselves in. And not always do they want to have the one-size-fits-all, knee-jerk, default litigation route with attendant costs, inevitable delays, and all under the glare of public scrutiny. Company clients find themselves in a situation or a dispute where they do want to vindicate a right or to get out of a situation, but they'll say to you in private, we want to do so as quickly and as cheaply and as privately and as quickly as I say, in order to get on with what we do best. And what we do best is business and making money for the company. I always remember a very famous quote by Lord Roger, who said that he has never come across a client who wanted to set a precedent. In other words, why were they in litigation? It wasn't to set a precedent for the lawyers, it was to come to some kind of solution, and as I say, as quickly, cheaply, and privately as possible. And sometimes that involves trying to maintain the business relationship that has already broken down. And therefore you can see why mediation as a route may well be attractive. With arbitration, you may not realize that it is the default and most often used dispute mechanism, resolution mechanism, and procedure in the world. Some say, because it's confidential, we don't have any clear figures, but some speculate that 90% of the world's disputes are resolved by arbitration. It is attractive to parties because it's confidential, it's adjudicative in the sense that there is a decision on the merits by a third party neutral, and results in enforcement cross-jurisdictionally under an international convention called the New York Convention. Added to that, of course, you will all appreciate, is this factor, which is the increasing electronic commerce and cross-border trade. In my view, the influence will continue as trade increasingly operates across different countries, different borders, and different jurisdictions. Now, I want to say a few words about the interrelationship between courts and these dispute resolution mechanisms. The courts have consistently supported arbitration in challenges to arbitral jurisdiction, supervision of arbitrations, and indeed at the end of a process in the recognition and the enforcement of awards. And with mediation, the courts are increasingly supportive of mediation as a process. And just this year, it's early days, but from 4 cases already this year, the court is developing a body of case law which would suggest that parties to court cases may suffer financial consequences if they unreasonably refuse to offer an offer to mediate the dispute. That's arbitration, mediation. The last one is early neutral evaluation, where the court has now determined that it has power under the CPR to direct cases away from court and into early neutral evaluation. Now, you might be thinking, how does all of this affect you? Well, I would say to you guys are the next generation. And I might speculate that all of these forms of ADR will, by the time you get into practice, you will be more conversant with them. You will be used to using them. I feel that all of these things will be used more frequently and interchangeably in the future. To the point that you will be dispute resolution literates, is what they say, literates. You are able to jump from one resolution mechanism into another and able to advise clients on the most innovative and tactical ways to resolve those disputes. Now, what might you do presently? What could you do now if you have an interest in what I've been talking about? Well, you might want to read up on mediation and arbitration. It's possible also for you to do entry-level qualifications in mediation and arbitration. At 3PB, we are in the process of upskilling our junior barristers as we see this being a direction of travel. We are developing international contacts and taking increasing amounts of international work. What I would say in conclusion to you is working with different cultures, different countries, and using different laws, and of course, the option for international travel, all bring benefits. But I think the key thing for you to take away from this is not only will your clients want you to be able to do all these things, they will expect you to do all of these things, and they will call upon you to have that versatility and adaptability in order to advise them in their best interest as to how they can resolve the disputes that they find themselves in. So to conclude, I would say to you, if you do join 3PB, it would be really great to have you on board with the project that we have just started and which we will continue with. Now that's all I want to say, and I want to pass over now to Rob and I think Joe, who are going to be talking to you about legal books.
Thank you very much, David. Well, as David says, you join us now for a brief talk, in fact, a very brief talk about writing legal books. And to explain a little bit about my background, I'm a practitioner that specialises in really purely property work at 3PB. I wrote a textbook on property law back in 2016, which unfortunately means that I'm going to have to start updating it very, very soon indeed. I'm joined today by Joe England, who's also on the line. Joe is a barrister specialising in employment and commercial law and has also published a textbook. So, Joe, why don't you get us started? Tell us, what was your book about, why that topic, and why did you decide to write?
Hey, hello everyone. Here is my book. As you can see, it's called NHS Whistleblowing and the Law. Just to explain briefly what whistleblowing is essentially when someone raises a concern and it ends up in an employment tribunal because they say that they suffered at work as a result of raising that concern. Maybe they say there was some retaliation of some sort. In terms of why I wrote a book on this topic, I was always told that you don't choose your specialism chooses you. And that's certainly true in my experience so far. In about my first year of tenancy, I did a big case, on whistleblowing. The successful claimant who I represented was awarded over £1 million. So it was quite a big claim and it received lots of attention. On the back of that, I did some more whistleblowing cases. One of them was an important appeal case, etc. And that essentially was projecting me towards this area of whistleblowing. A publisher then approached me, I think in mid 2018, and said that they'd seen that I am doing a lot of work in this area. They wanted a book on this point. Would I do it? At that stage, I'd thought about writing a book, but if I'm honest, I presumed it was something that was much more senior. But I realised it was good as a junior to project myself that bit further. It is a very niche area. What I've written about, as you can see, is NHS whistleblowing in particular, so it's even more niche. But that for me gave me the confidence that I had the experience in such a niche area. And it's only about 100 pages, the book, so it's more like a handbook. And it's been very successful since. What about you, Rob? I think yours is slightly different. Obviously, what was your book about and why did you choose that topic?
It is. It's quite different to yours, actually. But I suppose my publication was mainly different because it was a book that I co-authored rather than wrote myself. In my case, the text was written with a senior member of these chambers, William Webster, who's actually was my pupil master quite a number of years ago. It was a book orientated really towards development work and developers of land. So the book has two sections. The first section was on real property, easements, restrictive covenants, those sorts of things, the sort of things that can impede the development of land. And the second part was on planning controls. So the book is quite different in terms of certainly the subject from yours. As for the reasons that I wrote it, my reasons for that are different as well, which is that when I was approached by the publisher, or rather when William Webster approached the publisher back in 2016, I had a much broader practice than the practice that I have now. I was doing, in fact, more than one area of civil law. And my view was that, and you've heard this today, in fact, from David Parrott, that the legal services market is changing. I think it's becoming much more specialist. And really, the book was a tool or a platform in which I could try and become a specialist myself and to market myself as a specialist and an expert in property law. So that was really the reason that I wrote the book. But tell me, Joe, what about your working methods? How did you manage the writing process around your busy court practice?
For about 6 months, I kidded myself when I tried to fit it in around other work. In employment, you often get fairly long trials, and when they would settle, I had it in my head that I would just do the work when they settled, etc. That didn't work. Typically, I'd have something else that had a more pressing deadline, and ultimately, the deadline for the book wasn't set in stone, and nothing major happened if I pushed it on a bit. And being practical, other work would come along that I would be paid for. Writing a book, you don't generally get paid to actually write the book. You get a small bit of money afterwards for royalties. And frankly, I just took the opportunity to do the paid work. So in the end, to actually get around to doing it, I took a solid week off, dedicated the time to that. I wrote about 2/3 of the book in that time, tackled the hard bits, the bits where I really had to think, and then managed to fit in the other third or so during the weeks that followed. I had a break away from it, a couple of weeks or so, went back to proofread it all, made some changes, proofread it probably once more. And I think if you added up all of that time, albeit broken up, if you added that together, I probably spent about 3 to 4 weeks writing it in total. What about you, Rob? How did you find writing it alongside your practice?
3 to 4 weeks on 100 pages, I think is quite impressive, I say. I suppose really it's the same as you, which is that I wasn't quite sure how it was going to work out around my practice. But you simply have to sort of roll with it and sort of see how you're working, how it affects your work and what your working methods are. For me, it's more about compartmentalizing. So I would normally take off a Friday and a Monday. I would then have effectively several blocks of 4 days. So I would have 4 days working, 4 days on the book, another 4 days working, and then say 3 or 4 more days on the book. I suppose the negative with that is, of course, that you don't get any weekends. You're simply working all the time. But it's not forever. You know the end is coming. You hope it'll be worthwhile. And certainly in my case, I don't know about yours, Joe, I was probably on the first plane out of the country as soon as the book was was finished. So there are ways of dealing with it and encouraging yourself, incentivizing yourself to complete the task. But I think it was quite manageable personally around work. It was just a bit tough for a little while. But in terms of marketing, Joe, how have you marketed the book and what have you sort of discovered about how it's impacted your practice? Has it been worthwhile?
the main resource for me in terms of marketing has been talks. So I've done several talks where we've had different solicitors, and one of the many advantages of 3PB is that we've got these bases in other geographical areas. So I did one in Bristol, I did one in London, I did one in Oxford and Birmingham, etc. We gave away a copy of the book at that talk to make it a bit fun. I've tried to use social media a lot, so LinkedIn and Twitter, and afterwards, any new case that comes along in the area of whistleblowing, I've always tried to do an article or talk on that just to reinforce my specialism in that area and just remind people that that's what I do, remind them of the book. It certainly has been useful, and as is my experience so far, I've just built and built and built and get more and more cases and become more and more an expert in that area. What about you, Rob? I think you did at least some talks, didn't you?
It was very similar, actually. We did talks, we did seminars, and we also had a book launch as well, which was quite fun, actually. So largely the same as you, in fact. In terms of how it's impacted my practice, I think it's a hugely beneficial exercise. With the help of the clerks and chambers, I now purely do property work, which is what I was wanting to do. So from that perspective, it has been a success. I've also had work directly in as a result of the book. And in fact, about three and a half years ago now, I had instructions to council that came through which referenced a page within the book and actually asked, believe it or not, for advice on a particular point. The only sad thing about that was that I actually didn't write that page or that chapter. It was actually my co-author. I didn't quite have the temerity to say to her, actually, I didn't write that part, and simply advised anyway. But it certainly has been a hugely useful task for me, a hugely useful exercise. And as I'm about to start updating the next, I think it's really worth, particularly in your early years when you're trying to develop a specialist practice, I think it was a hugely useful exercise to undertake.
Great, thanks Rob. I think that's our time. We'll hand over now to our colleague Sunena, who will speak to you about further alternative ways to keep your practice fresh.
Good morning, everyone. I joined Chambers quite a few years ago, Bournemouth as a pupil in 2007, and I was in the same cohort as Caroline Stone and Matthew Cannings, who you'll hear from in due course. And at the time, I was hell-bent on becoming a criminal barrister. It was the basis I applied to Chambers. It was how I got pupillage, probably how I got tenancy, and the reason I ended up in Bournemouth in the first instance. And for the first 4 years of my practice, I did build a very successful criminal practice, thanks to the likes of Stuart Pringle in Winchester and my Bournemouth clerks, as well as my Oxford clerks. I was doing jury trials, I'd been led, and I had also done 2 cases in the Court of Appeal. So I was really pleased with how my practice was developing. But I also followed the advice of my clerks and tried to do other areas because the money was really dropping out of crime at that time, and we were starting to see a shift in legal aid work. So I also tried my hand at personal injury, social housing, trading standards, but I didn't love those areas like I did pure crime. Now, as is the whirlwind of life, my personal life took a bit of a turn. I met somebody, I got married, and I moved to London. Thankfully for me, Chambers had a base in London, so I was able to shift my life to 3PP London. Now, great for my personal life, not so much, unfortunately, for my professional life, because in reality, I could no longer sustain that criminal practice that I had developed over the last 4 years from London. I couldn't really travel for weeks and weeks to the likes of Bournemouth or Dorchester on the fees, because train fares were so expensive. I couldn't go to Devon in the same way that I'd used to. So, and when I arrived in London, we had 2 criminal practitioners. One was a silk, who was obviously doing very senior work, and another one was a very senior junior. So there wasn't really that flow of work that I'd been used to from Winchester Chambers and Bournemouth Chambers. Well, now, with the advice of my clerk at the time, based in London, I decided to apply for a secondment, and that was in July 2013. That was applied for, and I took up the role for 6 months as a case presenter for the Nursing and Midwifery Council. That enabled me for a really significant period to do misconduct and incompetency cases, bringing cases against nurses in their professionally disciplinary field. So effectively, I was a prosecutor for nurses in front of their professional body. And in a matter of months, I developed no knowledge of an area to quite a significant knowledge of an area that I had known nothing about previously. And before I knew it, the 8 or so years that have since passed, with the learning that I've had from the secondment, I've diversified my practice into professional disciplinary work, and I have been able to represent, as well as nurses, doctors, teachers, chiropractors, osteopaths, social workers, counsellors, such a full range of not only healthcare workers but others in their professional field. I've been very fortunate to be able to develop my practice further in the areas of maritime and fisheries, health and safety, and inquest work. But of course, as life throws these strange events at you, I then had another change of events when I became mum, and that was in 2016. I wanted to continue practicing. I remember waking up at 4:30 in the morning. I was 5.5 months into my maternity leave, and I was determined to take a year off at the time, and all I could hear was Twinkle Twinkle Little Star, and it was driving me potty, really up the wall. And I thought, I need to get my brain engaged again. So I went back to Chambers and I said, look, I need to work, please, after discussing it with my family. But of course, that busy practice that I developed before I went off to have a child was very difficult to maintain. I didn't want to not be around for my little girl. I wanted to be very much a part of her life at the same time. So those 3-week cases in Manchester or heading for weeks and weeks in Bournemouth were just not tangible anymore, were not really a possibility for me. And to further then, in the years that followed, opportunities presented, I was very lucky to be offered, because we'd had a very long discussion, my clerks and I, about how I was going to progress my career. And I did a secondment for National Grid PLC. Some of you may know it. It's a FTSE 100 firm. And I acted for a 13-month period as their health and safety and economic legal counsel. So I was a specialist legal counsel in their general counsel department. That gave me a fantastic insight into sort of electricity, gas, and the health and safety work that arises from that. Again, something I knew nothing about. I was quickly becoming quite an expert. And more recently, I undertook 10 months at the Financial Conduct Authority as an enforcement investigative lawyer, working on 2 of their very high-profile, highly sensitive cases, where 2 very large financial entities are being investigated for money laundering regulation breaches. And so what I want to demonstrate with these experiences is this: they've enabled me to continue working at the bar, to continue working in any event. My CV has really developed and grown off the back of the work that I've done. I've been able to work collaboratively with teams. So I've developed a new skill. I've managed lawyers and paralegals. I've worked collectively as part of groups. And I've also been able to have stability in my life and not have the crazy pace that you can sometimes have at the bar, traveling at, leaving your home at 5 o'clock in the morning or practicing till the late hours, which can be quite difficult when you're also trying to manage a child who doesn't sleep very well. So my advice is that if you're at a crossroads in your career, you don't know what to do, or you want a bit of a change, doing a secondment can be that absolute opportunity to work out what you're interested in and look at other areas that perhaps you'd never even considered were possible in the first instance. They can also, depending on the time of your life, help you to slow the pace down of what is happening, but at the same time, keep your CV fresh and interesting. But for me, it's also enabled me to confirm that I really enjoy being at the bar. I enjoy being self-employed, and that is, for me, a very good personality fit. Cheryl, that's how I did it. But what about you? Tell us about, how did you manage children at the bar?
Well, thank you, Sunena. My journey to the bar was a bit different. I was a divorced parent in my 30s with children approaching their teens before I even got to university, never mind to the bar. And I don't think there are many barristers who can boast of having been a hypnotherapist, a secretary, and a professional corporate wife in Japan for 7 years. I can't say it was easy, and I have to give somewhat reluctant credit to my ex-husband, and great credit to my parents for the level of support I got. But it did leave me when I got to the bar with a feeling I couldn't waste time. I tried to hit the ground running. I was interested in judicial careers, but thought in the early years, well, it was far too early. But when I was about 4 or 5 years into practice, I saw an advertisement in Counsel magazine for something called an examiner of the court. I'd never even heard of it. I looked it up and in fact applied. And I was intrigued to find out it's someone who takes depositions under CPR part 38.4. And these are depositions sometimes on behalf, for example, of a foreign government. The German courts in particular use this particular process. It used to be called rogatory letters. Or it could be a bedside deposition of someone who may not be able to attend court, for example, through terminal illness. So you turn up, you allow examination in chief and cross-examination, and you take a note either yourself or with the help of a shorthand writer. For foreign depositions, you attend at solicitors' offices usually. The court in question sends the questions over which you ask, and they also direct you on how the evidence is taken. For example, with the German courts, you don't take it under oath, and there are certain procedures that you have to follow. I really enjoyed doing it. It's not very onerous. I only did at any time 1 or 2 a year, and I came off the register in January 2019 because I had moved on to other things. I've always looked on examiner of the court. There was a really important and helpful good half step onto the judicial ladder, and something that's very easy to fit in with your career. I did, of course, take those next steps, but I'm going to hand over now to Matthew Cannings, from our Bristol office, who's going to take you through what happens and how he became a part-time judge and how he fits it into his practice. Matthew, over to you.
Thanks, Cheryl. Well, good afternoon, everyone. I'm Matthew Cannings. I'm one of the barristers at 3PB, and I specialise in property work, doing some commercial work as well. And as Cheryl says, I'm also a deputy district judge, so that's what I'm going to have a few minutes on with you now. My background to the bar is relatively conventional. I did a law degree at King's College London. I see there's a few people from King's College London today, so hello to my fellow alumni. And then I did what was the BVC at the time, now the BTPC at Nottingham Trent. I didn't get a pupillage the first time round, so I got a place on a master's course at Durham University, and while I was doing that, I was offered my pupillage at 3PB, and I've been here since then. And last year, I was appointed as a deputy district judge on the Western Circuit, which is where I'm based, having applied the previous year. And just like Sunena was talking to you about things that can keep one's practice fresh, it strikes me that amongst other things, a part-time judicial job is another way of doing that. And the way the part-time judicial system works is the court calls upon, at various levels, part-time or full-time practitioners, part-time judges, to take the load of some of the court cases. And in my case, I sit in the county court primarily. Ever so occasionally it might be on minor high court matters, but essentially it's the county court sitting on a whole range of civil disputes. So although I do property and commercial work, as far as the district judge role goes, I might be sitting in on personal injury cases, insolvency cases, all sorts of small claims cases, and I also do matrimonial finance work. As to other judges or other part-time judges, part-time circuit judges are called recorders. You could also be a part-time high court judge, a deputy high court judge. And there are other roles, quasi-judicial roles as well, like Cheryl says, examiner of the court. Matthew Wyard, who you spoke to or you heard from earlier, he has a part-time quasi-judicial role. The first tier tribunal has part-time roles as well. So there are lots of different options available to practitioners. I decided to apply to be a deputy district judge because my practice is mainly civil, and I thought that would be the most conducive to my practice. And what I have to do is sit for around 30 days a year as a deputy district judge. So I still consider myself to be a full-time barrister, as well as for 2 or 3 days a month being a judge. I think it improves my practice, my abilities as a barrister. I'm able to see from the judicial side, the sort of things that advocates and litigants do that are helpful. I'm also able to see the certain things that litigants and advocates do which are certainly not helpful and don't assist the court. And hopefully that improves my abilities as a barrister and makes me provide a better service to my clients. I also find it interesting. It's probably not right to say that everything is fun or enjoyable, because you have to make tough decisions, and sometimes you have to make serious decisions which are going to impact upon people and their homes and their livelihoods. So to say it's all fun isn't quite right, but I do generally really enjoy what I do, but I also enjoy going back to my day job at the end of it. It also opens up another line of career progression, because I'm a deputy district judge at the moment, which is probably an entry-level judicial position, but there are other part-time judicial posts, such as, I say, being a recorder, being a deputy high court judge, and maybe I could think about going in that direction when I'm more senior. It, of course, also leads to full-time judicial appointments, and it's right, I think, that almost all full-time judges have had part-time judicial posts beforehand, so it leads in that direction as well, although that's not what I have in mind. But it certainly adds something to my day-to-day working life. No day is ever boring. And as I say, one day I might be working on something I know about. I might be working on possession lists and making possession hearings and dealing with the sort of cases I might normally be dealing with as a barrister. But then the next day I might be working on a matrimonial finance list and dealing with divorce cases, which isn't something I do in my barrister role, but it is now something that I deal with as a judge. So it's all very interesting. It adds something, I hope, to my abilities as a barrister, and certainly keeps me interested and on my feet, shall we say. But what I'm going to do now is pass over to someone who was previously a deputy district judge. He's now a recorder. He's also our head of chambers. It's David Barclay QC, and he's going to talk to you about taking silk. Thanks, David. Oh, you're on.
Thank you very much indeed, Matthew. And it's wonderful to see so many people here today. And can I specifically welcome all those people who've attended and who have an interest in joining this wonderful profession to which we belong. We welcome you, and we recognize your aspirations, that you wish to succeed in this profession. Speaking very briefly as head of chambers, 3PB is one of the largest sets in the country, and we've recruited some really wonderfully talented people as pupils from many diverse backgrounds over the recent years. And I'm really proud of the success of our pupils. And I just want to say a few things, if I may seem counterintuitive, talking to people who are at the threshold of their career, to talk a bit about taking silk or becoming Queen's Counsel. At 3PB, we've got 14 Queen's Counsel, including David Parrott, who you heard from previously. And as you know, it's an annual appointment by the Queen on the advice of the Lord Chancellor, who accepts the recommendation of the Independent QC Selection Council. And that day, which I obviously still remember vividly, it was in 1999, a long time ago, when you attend the House of Lords with your family members and your clerk and receive the letters patent from the Lord Chancellor is a wonderful occasion, an unforgettable experience. And it's also, not only is it seen as a recognition of your professional success, but it's an occasion to wear a full-bottomed wig, your breeches, your tights, your silver-buckled patent leather shoes. So why is all this relevant to you at this juncture? Because the appointment of Queen's Counsel is unique, because it's all about excellence in advocacy. You don't take a test, you don't apply for a membership of a specialist college, but the context is that you've been recognized by your peers and by those before whom you appear as being one of the leading advocates of your generation. And that's why it's relevant to you, because you have chosen a career where you've already identified that it's a privilege to be a professional advocate. That's what you want to do. You want to represent the interests of others, whether they're people who are vulnerable, whether they're people who are corporations, whoever they are, they need an articulate voice, and you can be that voice. And if you demonstrate your skills in terms of persuasion, you will be recognized. The bar may be a difficult profession to access, but it is a true meritocracy in the sense that everything you do is visible and is open to criticism and is open also to tremendous appreciation and praise. Now, whilst you may come and you may be the sort of people who've got a 10-year plan or a 15-year plan and you've already decided you're going to take silk, I suggest you begin with a case immediately in front of you, that you start with the opportunities you get to do advocacy in whatever court or tribunal you get to do it in. Because advocacy is a lifelong commitment to self-improvement, and you go on learning. You learn from your colleagues, you learn from your opponents, you learn all the time. And the bar has, for whatever reason, identified this differentiation between junior barristers and leading counsel. And this goes back to 1597, when the very first letters patent were granted. And it's a controversial system because it has in the past been a way of maintaining privilege. It's been in the past, there's been elements of cronyism, and it's been open to criticism, so much so that in 2003, I think it was 2004, they suspended it. But the overwhelming majority of opinion at the time was that they wanted to reinstate it, and so they did, with an independent counsel. But let me tell you something about where you can help the profession. I've not done a profile of every one of you, but you've got to recognize that even today, the number of people who've taken silk and become Queen's Counsel reflect some of the historic problems that we've had about the way in which people are represented within our profession. So, for example, whilst I mentioned 1597 being the first appointment of Queen's Counsel, it wasn't until 1949 that Helen Normanton and Rosie Halbrom became the first females to become Queen's Counsel. And even today, taking the figures as of 2019, of the 1,751 Queen's Counsel in England and Wales, only 293 are females and only 138 are from a BME ethnicity. So there you have it. You have an opportunity not only to succeed as you want to do for yourselves, but you also have the opportunity to change that demographic. And I believe that the bar is moving in the direction whereby by the time you're in a position to apply for silk in whatever institution it exists, both the criteria and the considerations will be quite different. At the moment, what I would say to you is that the advantages of being a QC is that it gives you, rightly or wrongly, an internationally recognized standard. It allows you to command authority. It means that the nonsense you talk may be listened to with greater credence than that of your junior colleagues. That you can get to work collaboratively with junior counsel. That's an important thing for me, because the bar can be quite isolating and atomizing. Although you get the fraternity, and 3PB, we make a great deal of trying to work with comradeship and fraternity within our membership. Equally, being in practice on heavy cases, it's wonderful to be able to work with talented barristers who are your junior barristers on cases. Then you can also be much more selective about the work you do when you're a QC, and you don't have to do as much paperwork, given the fact that your rates are usually too high. And that's the final point. Financial success, you are expensive as a QC, but it doesn't always achieve what you intended to. There can be strange consequences. I have known people at the bar who've taken silk at the wrong time, in the wrong area, and they've priced themselves out of the market, and they've seen actually a decline in their income. So it's a fascinating element of this quirky profession with its own anachronisms that represents the Bar of England and Wales. I hope that you continue to operate as you are doing with the ambition to succeed. Obviously, we know the hurdles you've got, and we hope that those of you who are persistent and who are able to secure a foothold in this profession will also one day look at taking silk as one of the ambitions that you can aim for. Thank you very much indeed.
David, thank you very much for that wise words, which I'm sure we'll all listen to. We're going to move on now to taking some questions. We've been answering some questions on the Q&A, but we've got some that need to be answered live. So I'm going to just kick off with a couple and then pass on to one or two other people. So I've got a question here which it encapsulates a question that I quite often get asked, which is, what are the 3 things that a pupil should ensure they've done before attempting to secure a pupillage? Well, my answer to that is there are a lot more than 3. But the 3 most important are probably these. You can demonstrate academic or intellectual achievement through your degree, or any postgraduate work or workplace achievements. We don't count courses which aren't examined or assessed, such as mediation, but significant intellectual attainment outside law is very much taken into account. Secondly, that you can demonstrate a knowledge of the bar and what you're getting yourself into. By taking mini pupillages if you can. We know it's difficult at the moment, attending webinars like this one, pupillage fairs, there are some virtual pupillage fairs coming up, and reading up on chambers. There is a lot of information out there these days, so there's no excuse not to know about your chambers and for not understanding that, for example, there's no salary, you're self-employed, and you do have to be very self-reliant. It's not to say you can't expect support. We pride ourselves on being very supportive to our pupils and indeed to each other as members of chambers. But in the end, you're responsible for yourself, and you do need to grasp that. Thirdly, you've got to be able to demonstrate that whilst, of course, you're incredibly intelligent and accomplished with a great deal to bring to chambers, you understand that you still have a lot to learn. Being arrogant and acting as if you already know it all will lose you a lot of points. It is an error I see a lot, I have to say, but you need to look at it from our point of view. Anyone who is a successful barrister knows in their heart of hearts that it's a lifetime learning process. You never know everything. Things change around you. You have to be able to adapt and grow. The pandemic, for example, has been a case in point. Barristers at all levels have had to make extraordinary adaptations to their working practices. Clerks like Stuart have had to change theirs, turning in 2 or 3 days. So anyone not prepared to open minds and adopt their new ways of working and learn new things, and in some cases actively resist learning new things, can, and in many cases already have done, fall by the wayside. Leading on from that, somebody's asked if a master's is required for pupillage, and the short answer is it's not required. Your basic requirements are a law degree, conversion course, or doing the BPTC. The long answer is that it depends on everything else that you have. If you have a first-class degree, for example, a master's won't add anything on our initial marking scheme. If you have other obvious intellectual or academic achievements, it's not necessary. We're very conscious that not everyone has the time or the resources to do additional academic work, but of course with everything it probably helps. Matthew, I'm going to turn to you for the next question, if I may. This is a question and an interesting one at the moment, given the circumstances. How is it best to demonstrate, for example, an interest in property law during the crisis, considering that many property-specific moots, insights, events, and essay competitions have been cancelled until 2021?
Thanks, Cheryl. Yeah, I had a thing about this. Thank you for the question from Anastasia. It's difficult at the moment, is the reality, and it's not the same as it might normally have been or would normally have been in less difficult times. Although these answers the questions about property law, I think this probably relates to any specific area of work. The first thing that is still possible is still observing court hearings. It's a bit different at the moment, but courts are still open, they're still public, hearings are still public. So to the extent that there are hearings in person, if you are content to do so, you are still allowed to go to court and watch. So you may find things such as an interesting fast-track trial, or you might find a possession list. Possession lists are easier to identify in advance. The topics of a trial, not so much. Equally though, even if hearings are being conducted remotely, people are still allowed to attend. You don't want to cause difficulties, but they're still open hearings. And if you look at lists, there are ways people can remotely attend via video or telephone hearings that are going on like that. So don't rule that out. I also suggest keeping an eye on judgments, appeal judgments. So Court of Appeal judgments and Supreme Court judgments are a good place to start. There are always cases coming out in the property sphere. And one thing it strikes me you could do at the moment is you could watch the live stream of the Supreme Court. And if that comes up in an interview, it strikes me it might be a particularly good answer to say, well, not only have I read this judgment, but I actually watched the Supreme Court deliver it, and this is what I think. So those are ways round the problems. I'd also have a look at online resources. Chambers websites or solicitors websites, often they put videos up, like we're putting a video up of this and of last week's talk, but chambers or solicitors will sometimes put on mock trials or things like that to assist clients. There's nothing to stop students, prospective barristers, having a look at those things as well, so that might help you. And finally, I thought attending more online or virtual seminars, a lot easier at the moment. Again, lots of solicitors, lots of professional bodies, and obviously barristers' chambers are putting on seminars and lectures. Lots of them are free to attend, and you can do that from the comfort of your own home. So again, while it's difficult and different at the moment, there are still plenty of ways you can beef up your property knowledge, but that applies to other types of work as well, I think. Thanks, Cheryl.
Thank you very much, Matthew. Matt, there's a question in from Anthony Miller. Hello, Anthony. Which he says, how hard is it to establish a regular income in the first year of pupillage? And also, in a sense, connected with that, a question from Veronica about how would you explain your first week as a self-employed barrister? Can you deal with those?
Yes, I can. Thanks, Cheryl, and thanks to the two attendees who sent those questions in. Dealing firstly with the issue of income, I think it's very difficult for anyone who's self-employed to say that they get a regular income. It doesn't work in the same way as getting a salary. You're not guaranteed, obviously, a certain amount of money at the end of each month. It gets easier the more you go along, but particularly in your first year after pupillage, the one advantage that you do have is that in your preceding year during your pupillage, you've generally had some level of guaranteed earnings, be it via a pupillage award or a grant, and therefore you can put mechanisms in place to try to save up to make the transition into full-on self-employed practice slightly easier. But the reality is you're never going to have a completely regular income when you're self-employed. It goes in peaks and troughs alongside the levels of work that you get. Moving on to the second question, well, this is something I can hopefully deal with fairly swiftly because I only joined 3PB I think about 5 months ago now, so I can still remember my first week as a self-employed barrister. Personally, I enjoyed it. It was nice to get to know everyone in chambers, including the clerks. Insofar as work was concerned, I was slightly busy because I alongside Robert and Joseph, also write a textbook, so I was dealing with some of that. At the same time, I had a couple of paperwork instructions that came in off the back of what I did before when I was an employed barrister, and then I was preparing for a trial I had in my second week. So again, it was a fairly mixed first week, but all in all, it was thoroughly enjoyable. I hope that answers the question, Cheryl.
Thank you very much, Matthew. We're coming to the end, but I think we have time for one more question. So, Naina, can I ask you to perhaps answer this one, because I think it sums up to a certain extent what we've all been trying to talk about. So the question is this: is it easy to, and it's from Elizabeth Jones, is it easy to balance your career as a barrister with other legal roles? And have you ever witnessed any barrister's career suffer as a result of taking on too much?
Thank you for the question, Cheryl. I think that when you're at the bar, you have to be driven to get pupillage, to obtain tenancy, then of course to have a successful practice. So the starting point is that many of us do things other than being just barristers. We may do things externally to the work that we do, part-time judges, as Matthew said, writing books, and all of those other things. And I think you've got to just make sure you get a balance, which is working out how much time your part-time role is going to take and impact on your career. And if it does impact too much and you feel that it is having a negative impact, then you may want to perhaps reduce the work that you're doing, whether it's within chambers, i.e. the cases that you're taking on, or even that part-time role. I'm a queen of taking on too much, so I completely understand what it's like. And I've had to step down when I became a mother from some of my committee positions because I knew that I couldn't give focus to all of those things as well as maintaining successful practice. So just be really realistic with yourself, because you don't want it to impact on you in court when you're in front of your peers, in front of judges, and you're exhausted because you can't remember the question being asked or being able to cross-examine witnesses properly or giving closing speeches, submissions. Be fair to yourself. There's a lot of well-being at the bar at the moment. A lot of barristers have had breakdowns, nervous breakdowns and the like because they've taken on too much. But we're all a lot more understanding, as are our clerks, about the fact that we need to get a good balance between personal and professional lives. Thanks, Cheryl.
Thank you, Sunena. You're absolutely right. We're very keen at 3PB on well-being. We do, in fact, do some stress management and relaxation type work with our pupils when they come to us, because we have all seen people burn out. We've seen people with alcohol problems. We've seen people with other problems, things which until quite recently we didn't talk about, but I think do need to be opened out and talked about and dealt with, which I think we're all trying to do. Well, unfortunately, talking about taking on too much, we've now reached the end of this session. So I'm sorry if there were any questions we didn't manage to answer. I hope that if you go through this, or perhaps watch the first webinar from last week, if you haven't watched that, it should answer most of your questions. We will be attending the virtual Pupillage fair on the 17th of October, so you can come and chat to us at that. It's going to be a learning curve for all of us. Most of this 4 or 5 months has been. So I'd like to thank all the panelists for giving up their time. Very busy barristers, all, I know, and the time that they've given up is precious to them, and also I hope precious to those of you who've been watching. Thank you all very much indeed, and we will hope to see you in the autumn. And it's goodbye from me, and it's goodbye from them. Bye-bye.